Hey everybody, this is Ryan McClanahan with historythroughcards.com. Hope you're all doing very well today. As you can see in back of me here, I have a huge library of auction catalogs that I use for reference resource material. I'm very careful of using these things as resource or reference material in my articles. In fact, it almost never happens just because, well, I think you're going to find out exactly why as I go along with this video. And today I wanted to tell you a little bit about one such auction that has really had a life of its own over the last 20 plus years. And that is this particular auction right here. This is the Barry Halper catalog from 1999 from Sotheby's. And oh man, it's a little on the heavy side. However, I know that there's a lot of people who have said over the years that Barry Halper was a fraud, and I don't like to call people out. I just don't, unless that there is something that I can absolutely 100% connect the dots to that person to say that they've committed fraud. And then, I have to usually keep my sources pretty tight. And so one source will never do, obviously. You just don't want to have one source for your article or for your information that you're going on. You want several. And so today I found a very interesting, to say it's not an article, but it is a lawsuit uh, in which Barry Halper, his estate and his name was brought into. And I want to read that court case. And I find that court cases are really kind of interesting things to latch on to. I'm not a lawyer, but I do know quite a bit about the law, and so I'm gonna tell you a little bit about this court case as told by the judge, and then I'm going to come back and tell you a little bit more my own personal feelings about this. So stick around. This is Jacobs vs. Halper, July 22nd, 2015. Opinion by Wendy Beetlestone, District Judge. Introduction. The dispute concerns plaintiff Michael Jacobs' purchase in December 1999 at a Sotheby's auction of a 1951 Willie Mays New York Giants signed rookie road jersey and a 1950s Willie Mays New York Giants travel bag, which he subsequently learned were inauthentic. Plaintiff alleges that the defendants knew the items had not been authenticated at the time he bought the item, making written representations in the auction catalog that they had. Plaintiff brings this lawsuit against three separate groups of defendants. 1. Sharon Halper and Barry Halper, Inc., collectively Halper, who were alleged to be engaged in the business of buying and selling sports memorabilia, and who were the previous owners of the Mays jersey and Mays travel bag. 2. Sotheby's Inc., Sotheby's Park Burnett Inc., Sotheby's Holdings, and Sotheby's, collectively Sotheby's, all of which allegedly served as the auction house for the sale of the Mays jersey and Mays travel bag. And 3. Gray Flannel Auctions Inc., GF Auctions for short, and Gray Flannel Collectibles Inc., GF Collectibles for short, collectively Gray Flannel, which allegedly specialize in authenticating, appraising, and auctioning sports memorabilia, and who were represented by Sotheby's to have authenticated the Mays jersey prior to the Sotheby's auction. Each of the defendants has filed a motion to dismiss pursuant to Federal Rule of Civil Procedure 12b-6. The Gray Flannel defendants have also moved the court for dismissal pursuant to Rule 12b-2 for lack of personal jurisdiction. The court held oral argument on the motions. Background: Sotheby's advertises the Halper collection. In or about early 1999, Sotheby's advertised an auction sale of Barry Halper's collection of baseball memorabilia, which was described as, quote, the world's largest and most significant private collection on baseball. With the help of Gray Flannel, Sotheby's and Halper published a three-part auction catalog entitled The Barry Halper Collection of Baseball Memorabilia, the Halper Catalog. The Halper Catalog stated that the auction would establish new standards for the hobby in areas of condition, authenticity, provenance, and historical significance. Further, the Halper Catalog represented that Gray Flannel had authenticated all the uniforms and jerseys in the auction. Specifically, page 37 of the Halper catalog states, quote, Gray Flannel has authenticated all uniforms and apparel, excluding most baseball hats. Plaintiff's purchase of the Mays jersey and travel bag. Plaintiff obtained a copy of the Halper catalog in or about the summer of 1999. The catalog described the Mays jersey as, quote, one of the most important pieces of memorabilia relating to Willie Mays' glorious career, unquote. On around September 29, 1999, plaintiff bid by telephone on the Mays travel bag and the Mays jersey. Plaintiff was the successful bidder on both items and paid $8,625 for the bag and $63,000 for the jersey by wiring the money plus the applicable sales tax to Sotheby's. The Halper catalog included a copy of Sotheby's conditions of sale and terms of guarantee. The terms of guarantee set forth the following provisions. Authenticity. If within 5 years from the date of sale of a purchased lot, the original purchaser of record tenders to us a purchased lot in the same condition as when sold, and it is established that the catalog description of the lot as it relates to its authenticity as defined above is not substantially correct based upon fair reading of the catalog as a whole, the sale of such lot will be rescinded and the original purchase price refunded. Sole remedy. It is further specifically understood that the remedy set forth herein, namely, the rescission of the sale and refund of the original purchase price paid for the lot, is exclusive in lieu of any other remedy which might otherwise be available as a matter of law. In addition, the conditions of sale included a New York State choice of law clause which provides the conditions of sale and terms of guarantee as well as the purchasers and our respective rights and obligations hereunder shall be governed by and construed and enforced in accordance with the laws of the State of New York. By bidding at an auction, whether present in person or by agent, order bid, telephone, or other means, the purchaser shall be deemed to have consented to the jurisdiction of the state courts of and the federal courts sitting in the State of New York. Plaintiff retains Leland Collectibles to appraise the auction value of the Mays jersey. In or around July 2012, plaintiff retained Leland's Collectibles of Bohemia, New York, to appraise the Mays jersey for insurance purposes. At that time, Leland's appraised the Mays jersey at $400,000. In or around June 2013, plaintiff entered into a written sales agreement with Leland's in which Leland's agreed to purchase the Mays jersey from plaintiff for $675,000, subject to the approval of a third party to whom Leland's had agreed to sell the jersey. Leland's and or its prospective buyer thereafter retained Mears to authenticate the Mays jersey. Mears examined the Mays jersey and concluded that it was inauthentic. As a result, Leland's rescinded its sales agreement with plaintiff. At the same time, Leland's advised plaintiff that the Mays travel bag was also inauthentic. Plaintiff seeks explanations from Sotheby's and Gray Flannel. On September 20th, 2013, plaintiff advised Sotheby's by letter that he believed the Mays jersey was counterfeit and intended to pursue recovery of his damages. On October 7th, 2013, Sotheby's sent a response letter noting the expiration of its 5-year guarantee of authenticity and denying plaintiff's claim in its entirety. On March 19th, 2014, plaintiff sent a letter to Gray Flannel advising them he had determined that the sports memorabilia he had purchased from the Halper auction was inauthentic. In June 2014, plaintiff's counsel spoke with counsel for Gray Flannel by phone and requested information as to whether Gray Flannel had in fact authenticated the Mays jersey. Gray Flannel did not respond. Plaintiff obtains documents regarding Halper collection. During the course of discovery in this matter, Sotheby's produced documents showing the business relationship between Sotheby's and Gray Flannel in connection with the Halper catalog. These documents include written terms of agreement between Sotheby's and Gray Flannel Collectibles for cataloging and condition reports up to 1,000 unspecified uniforms from the Halper collection for a flat fee of $50,000. The contract between the parties does not specifically provide that Gray Flannel would authenticate the collection. Similarly, the contract does not suggest that another party was hired to authenticate any items. Nevertheless, the produced documents include a March 22, 1999 letter from Gray Flannel to Sotheby's, which proposed language for inclusion in the Halper catalog. Gray Flannel wrote, "We at Gray Flannel Collectibles would sincerely like to thank Sotheby's, Rob Lifeson, and Barry Halper for selecting us to authenticate, catalog, and evaluate the greatest uniform collection extant. It was well worth the many early mornings and late nights of work needed to complete this labor of love. A director's love is the play, an artist his painting, ours is game-used jerseys. Our deepest gratitude is extended to James Gates at the Baseball Hall of Fame Library and Mark O'Conan. Their help was invaluable." Discussion. Plaintiff asserts a number of claims against each of the defendants: misrepresentation and fraud. Count 1, negligent misrepresentation. Count 2, violation of New York General Business Law, otherwise known as GBL 349. Count 3, violation of Pennsylvania's Unfair Trade Practices and Consumer Protection Law, also known as UTPCPL, and unjust enrichment. The Gray Flannel defendants argue that they should be dismissed for lack of jurisdiction. They also argue that Gray Flannel Auctions should be dismissed because it has no relationship with Sotheby's in connection with the Halper catalog. All defendants assert a number of arguments that would require dismissal of all or most of these claims, including arguments that 1. A statute of limitations has run out on all plaintiffs' claims. 2. The conditions of sale and terms of guarantee in plaintiff's contract with Sotheby's bars plaintiff's claims that it provides the exclusive remedy for this grievance, and 3. The economic loss doctrine bars claims for economic loss resulting from a contract. In addition, the defendants argue that plaintiff had failed to state a claim with respect to each count. The court addresses each argument in turn. Jurisdiction over Gray Flannel defendants. The jurisdictional issue boils down to whether a federal court in Pennsylvania has jurisdiction over New York corporations with their principal place of business in New York, whose only contracts with Pennsylvania are 1. participating in the drafting of a catalog that plaintiff contends they, quote, should have known, unquote, would be distributed to potential customers outside New York State, including potential customers in Pennsylvania, and two, maintaining websites that could be accessed by users in Pennsylvania. Participation in drafting Halper catalog. In its motion to dismiss, Gray Flannel argues that the court does not have specific jurisdiction over the Gray Flannel defendants because Gray Flannel lacks minimal contacts with Pennsylvania and the plaintiff's alleged injury did not arise out of or relate to any such contacts. Gray Flannel, noting that plaintiff's complaint bases its specific jurisdiction on the fact that Gray Flannel participated in drafting the Halper catalog, which was eventually sent to plaintiff in Pennsylvania. Gray Flannel argues that it never sent the Halper catalog to anyone in Pennsylvania, never directed or solicitations to anyone in Pennsylvania, including plaintiff, and indeed was not aware that the Halper catalog would reach Pennsylvania. Gray Flannel attached an affidavit by the president of Gray Flannel Auctions in support of these contentions, which says, in deciding a motion to dismiss for lack of personal jurisdiction, the court need not treat the plaintiff's allegations as true, but may consider affidavits and weigh any other relevant evidence in making this determination. During oral argument on the motions to dismiss, counsel for plaintiff argued that Gray Flannel Collectibles' participation in drafting language for the Halper catalog was sufficient for this court to exercise specific jurisdictions over it because Gray Flannel should have known that the Halper catalog would be disseminated nationwide, including Pennsylvania. Court requested supplemental briefing on the issue of personal jurisdiction, specifically directing plaintiff to provide binding precedent that the defendant is subject to specific jurisdiction when it knew or should have known that the publication it helped prepare would be disseminated in the forum state. However, in this letter brief, plaintiff rightly conceded that the case law does not support such a proposition, and that would be Cloth vs. South Christian University from 2008. And I'm not going to read the case law there because I don't really want to bore you guys. You can read that on your own. And then you have Worldwide Volkswagen Corp vs. Woodson, 1980. Martin vs. Goldwyn, that's 2007. And Helicópteros Nacionales de Colombia S.A. vs. Hall, 1984. And that says specific jurisdictions exist when the claim arises from or relates to conduct purposefully directed at the forum state. And if you guys want to read that stuff, by all means, I just don't want to bore you guys enough as it is. So we will go on to the next paragraph. Gray Flannel websites. In his letter brief, plaintiff advanced an additional argument for the first time that this court has jurisdiction over Gray Flannel defendants by virtue of their online sales and activity. In support of this argument, plaintiff contends that as early as July 11, 1997, both Gray Flannel defendants maintained highly active websites for many years which permitted customers both inside and outside New York to register and bid on various items for sale. Plaintiff argues that such operations may have included business transactions with Pennsylvania residents and marketing efforts directed at Pennsylvania residents. Gray Flannel maintains that these alleged actions are insufficient to subject Gray Flannel to either general or specific jurisdiction. General jurisdiction. Plaintiff contends that Gray Flannel's websites could create a basis for general jurisdiction under Zippo Manufacturing Company versus Zippo.com Inc., 1997. And its progeny. Oh, that's a strange word to use. Anyway, in Zippo, which has become a seminal authority regarding personal jurisdiction based on website activity, the district court considered whether a corporation's websites could subject it to jurisdiction in Pennsylvania. The court concluded that proprietary of exercising jurisdiction where on a sliding scale of commercial interactivity a website falls. Toys R Us Inc. vs. Step 2. Toys R Us Inc. vs. Step 2 SA 2003, citing Zippo. If a defendant maintains an interactive website that allows it to enter into contracts with residents of a foreign jurisdiction that involves the knowing and repeated transmission of computer files over the internet, personal jurisdiction is proper. On the other hand, if the defendant maintains only a passive website that does little more than make information available to those who are interested, there would be no grounds for personal jurisdiction. Here, plaintiff contends that these cases stand for the proposition that a defendant that maintains an interactive website could be subject to general jurisdiction in any state where it has continuous and systematic contracts. This proposition is not supported by jurisprudence. As an initial matter, it is important to note that in both Zippo and Toys R Us, that the plaintiff conceded that there was no general jurisdiction, and thus the inquiry was limited to whether the defendant was subject to specific jurisdiction in the forum state. Moreover, several courts in this district have concluded that maintaining a website through which customers can order products does not in its own suffice to establish general jurisdiction. And then it tells you to see True Position Inc. versus LM Ericsson Telephone Company from 2012, which states to hold that the possibility of ordering products from a website establishes general jurisdiction would effectively hold that any corporation with such a website is subject to general jurisdiction in every state. And then in another case law, Wilson versus RIU Hotels and Resorts from 2011, it states further, maintenance of a website which allows users to reserve accommodations at defendants' resorts does not demonstrate that defendant has systematic and continuous contact with Pennsylvania. As the Third Circuit has cautioned, the mere operation of a commercially interactive website should not subject the operator to jurisdiction anywhere in the world. Rather, for a defendant's website to constitute sufficient precedents subjecting it to general jurisdiction in Pennsylvania, first, the website must be highly interactive or allow customers the opportunity to enter directly into a contract with the defendant over the internet. Second, much like an in-print advertising campaign, the website must be central to the defendant's business in the forum state or specifically target residents of the forum state. And then they list a couple of citations here, which I'm not going to read again to you guys because it just doesn't really have a whole lot to do, I think, with the main article here. Here, plaintiff contends that gray flannel websites subject it to general jurisdiction here because residents of Pennsylvania were able to access those cities to register and bid on items. However, plaintiff has not presented any evidence or argument that the websites were highly interactive or engaged in significant commerce or otherwise intentionally target customers in Pennsylvania through their websites. And it tells you to see Seamline Bus Services LLC versus Vitable Inc. from 2014. I'm not going to go down that road either. So you guys can if you want, but good luck. In fact, plaintiff has not pointed to a single interaction between Gray Flannel and a Pennsylvania resident via Gray Flannel's websites, Even if he could, the court emphasizes that the burden for establishing general jurisdiction is high. Under recent Supreme Court case law, the relevant inquiry for general jurisdiction is not whether the defendant has continuous and systematic contacts with the forum state, but whether its consistent and systematic contacts were so great to render it essentially at home in that state. Farber vs. Tennant Trucks Lines Inc. That's from 2015. They go into court a few things here, which, again, I'm kind of trying to keep you guys away from because it's not pertinent, I think. Again, you can go down a lot of rabbit holes on these other court cases if you really wanted to, but you never know where you're going to end up. So I'm not going to do that to you guys. As the Supreme Court explained in Daimler, the at-home inquiry will, in all but the most exceptional circumstances, subject a corporation to general jurisdiction only in the two paradigmatic bases for such jurisdiction: its state of incorporation and its principal place of business. These affiliations have the virtue of being unique, that is, each ordinarily indicates only one place as well as easily ascertainable. Plaintiff has provided no facts to show that gray flannel defendants have systematic and continuous contacts with Pennsylvania through its websites, let alone contact substantial enough for the court to find that the gray flannel defendants are essentially at home in Pennsylvania. Accordingly, the court does not have general jurisdiction over the gray flannel defendants. Specific jurisdiction. Neither do the websites provide a basis for the court to exercise specific jurisdiction over the gray flannel defendants. Under well-established Supreme Court law, specific jurisdiction is appropriate only when, inter alia, the claim asserted against the defendant arises out of its contacts with the state. See Daimler again, and you guys can do that if you want. I'm not going to. There's no allegation in the complaint or in any plaintiff's briefing that plaintiff's injury arises out of the gray flannel defendant's alleged websites. In fact, plaintiff was not even aware that gray flannel operated a website until after the filing of his complaint. Accordingly, the gray flannel defendants must be dismissed from this action for lack of jurisdiction. Statute of Limitations. Defendants argue that plaintiff's amended complaint should be dismissed because each of the counts is time-barred by the applicable statutes of limitations. Notwithstanding, the forum selection clause in Sotheby's conditions of sale Pennsylvania law applies for purposes of determining the statutes of limitations. See Guar Trust Co. vs. York, 1945, for that one, holding that federal district court sitting in diversity must allow the forum's choice of law rules to determine the applicable statute of limitations. Period. Glock vs. Unis Corp. 1992, which specifically states choice of law provisions and contracts do not apply to statutes of limitations unless the reference is express. And this is why I don't like to talk about this kind of stuff with you guys, because a lot of it is boring and a lot of it doesn't really make a whole lot of sense, even if you're a lawyer. A lot of lawyers actually want to keep things kind of simple and not go by a lot of case law. That's really kind of up to the judge, I think. Again, case law can go down several roads, and a lot of times it kind of doesn't really make a whole lot of sense. Anyway, let me continue with this. The general rule is that Pennsylvania courts ordinarily apply the Pennsylvania statute of limitations. See Freeman v. Lawson, 1946. However, Pennsylvania's borrowing statute creates an exemption to the rule when the case of action accrues in another state. The borrowing statute provides that the statute of limitations, quote, shall be either that provided or prescribed by law of the place where the claim accrued or by the law of this commonwealth, whichever first bars the claim. emphasis added, and I'm not sure why, because the emphasis I would put is don't read this crap. Anyway, let's continue. Thus, the borrowing statute operates to bar the claim when two conditions are met. 1. The claim accrues in another state, and 2. The law of that state bars the claim before the Pennsylvania statute of limitations. Ross v. Johns Manville Corp., 1985. The first step in determining the effect of Pennsylvania's borrowing statute on this case therefore requires the court to determine whether the plaintiff's claims accrued in Pennsylvania or another state. A claim accrues for purposes of the Pennsylvania borrowing statute where the final significant event is that is essential to a suable claim occurs. Unlike Mack Trucks, in which it was clear under both Pennsylvania and Florida law that the plaintiff's claim accrued in Florida, it is not immediately evident where the final significant event that is essential to the plaintiff's various claims here occurred. On the one hand, plaintiff's claims arguably accrued in Pennsylvania and state in which he resided because the alleged fraud or misrepresentation was not complete until plaintiffs acted to his detriment by purchasing the Mays jersey and travel bag from his home in Pennsylvania. On the other hand, plaintiff's claims arguably accrued in New York, where defendants conducted the auction and where plaintiff sent his money to make the purchase. However, the court needed not wrestle with the issue for the purpose of this motion to dismiss because in his opposition brief, plaintiff contends that the Pennsylvania borrowing statute applies, thus implicitly accepting that plaintiff's claim accrued in New York. Sotheby's, in its briefing, provides no argument to the contrary. Court also persuaded by the similarities between this case and Foley v. Juron Associates, a securities fraud case in which a sister court concluded for purposes of determining whether or not to apply Pennsylvania's borrowing statute that the final significant event in securities transactions involving plaintiffs in multiple states occurred in New York, where the defendant transacted its business, not where the individual plaintiffs resided, and that was from 1986. The next question is, thus, whether the limitations period for each of plaintiffs' claims would be shorter under New York or Pennsylvania law. In answering this question, the court takes into account both states' limitations periods, including each state's laws on accrual and tolling. The provisions of Pennsylvania's borrowing statute unequivocally evince the legislative intent to prevent plaintiff who sues in Pennsylvania from obtaining greater rights than those available in the state where the cause of action arose. Pennsylvania and New York law. Here, plaintiff asserts cause of action for 1. Fraud and misrepresentation, 2. Negligent misrepresentation, 3. Violation of GBL Section 349, 4. Violation of the UTPCL, and 5. Unjust enrichment. Under Pennsylvania law, fraud and negligent misrepresentation have a 2-year limitations period. In New York, the statutory limitations period for both claims is 6 years. Under Pennsylvania law, plaintiff's claim for unjust enrichment has a 4-year limitations period. Under New York law, it is 6 years. The limitations period for plaintiff's UTPCL claim is 6 years. The limitations period for a violation of New York's General Business Law Section 349 is 3 years. Under both Pennsylvania and New York law, the statute of limitations begins to run on the date that the cause of action accrued. Under both Pennsylvania and New York law, the statute of limitations begins to run on the date that the cause of action accrued. In Pennsylvania, a case of action accrues when the plaintiff could have first maintained the action to a successful conclusion. That's in Fine v. Ciccio. 2005, citing a few other cases I don't really want to tell you guys about because it's not really important here. Similarly, under New York law, in general, a case of action accrues triggering commencement of the limitations period when all of the factual circumstances necessary to establish a right of action have accrued so that the plaintiff would be entitled to relief. Accordingly, under either Pennsylvania or New York law, plaintiff's cause of action accrued in 1999 when he purchased the Mays jersey and Mays travel bag. Thus, under Pennsylvania's borrowing statute, all of the plaintiff's claims expired long before plaintiff filed his complaint in 2014, unless the limitations period is told. The discovery rule. In Pennsylvania, each of plaintiff's causes of action is subsequent to the discovery rule. See Beauty Time Inc. vs. Skin Size Inc. That is a fraud case from 2005. And then you have Friedman vs. Haydinger from 2002, which is an intentional and negligent misrepresentation case, which they cite as well as a backup to this. New York's application of its discovery rule is more limited. It allows fraud and negligent misrepresentation sounding in fraud to be told for 2 years after the plaintiff discovers the injury. And again, they cite Cohen versus SAC Trading Corporation from 2013, which is internal quotation marks omitted. Okay, that's great. Why? Just because a lot of it doesn't really make a whole lot of sense for me to add it. But if you guys really wanted to learn more about why they came up with their decision, this citations of other cases may be kind of important. But again, if you really wanted to go down that road, go for it. It's just kind of boring, to tell you the truth, unless you're a lawyer, that is. Anyway, let's continue. However, New York's discovery rule does not apply to GBL Section 349 or unjust enrichment claims. Thus, the application of New York law requires dismissal of plaintiff's Section 349 claims, which accrued in December 1999 and cannot, as a matter of New York law, be told. Further, because plaintiff's unjust enrichment claim cannot be told in New York, it too was brought outside the New York limitations period and thus barred under Pennsylvania's borrowing statute. The remaining question before the court, therefore, is the impact of New York and Pennsylvania's discovery rule on plaintiffs' fraud claims. For the reasons set forth below, the court concludes that the plaintiff's fraud claim is told under both New York and Pennsylvania law and therefore cannot be dismissed on statute of limitations grounds. Plaintiff argues that the statutes of limitations should be told pursuant to the discovery rule because he did not discover his injury until 2013 when Mears examined the Mays jersey and informed plaintiff that it was inauthentic. Sotheby's counters that the discovery rule does not apply because plaintiff could have discovered his injury through the exercise of reasonable diligence as early as 1999 when plaintiff first purchased the Mays memorabilia. Plaintiff responds that it would be unreasonable to require him to have obtained an independent authentication of the Mays memorabilia because Sotheby's, one of the oldest and most venerated auction houses in the country, stated in the Halper catalog that Gray Flannel had authenticated the Mays collection. Relying on representation, plaintiff argues he had no reason to suspect inauthenticity and therefore did not seek to obtain an independent opinion on the authenticity of the Mays memorabilia until 2012, when he brought the Mays jersey to Leland's to appraise it for insurance purposes and did not discover that his items were inauthentic until 11 months later when Leland's found a buyer for the maize jersey and requested a third-party appraisal. Because the court finds, as addressed in section 4C below, that the economic loss doctrine requires dismissal of plaintiff's negligent misrepresentation and UTPCPL claims, the court need not address whether those claims are also barred by the statute of limitations. Looking first to New York law, the limitations period for fraud begins to run either when the claim accrues or when the facts constituting the fraud are discovered. New York courts applying similar facts to the insistent case have found that the plaintiff's claims for fraud were told under the discovery of the alleged fraud. In Rosen, cited by both plaintiff and Sotheby's in their briefs, the plaintiffs brought suit against an art gallery after learning that the painting they purchased 19 years before was counterfeit. The plaintiffs sued under a variety of rubrics, including inter alia, fraud, and breach of warranty. Like Sotheby's here, the defendants in Rosengard, the plaintiffs could have determined that their painting was inauthentic as early as the date of purchase, although the Second Circuit agreed that the statute of limitations barred the plaintiff's breach of warranty claim. It held that the discovery rule told the plaintiff's fraud claim, reasoning that New York courts have exhibited a reluctance to impute discovery to a plaintiff maintaining a claim of fraud who has no reason to suspect that he has been defrauded, and that on the facts as alleged, the Rosens had no reason to suspect the authenticity of their painting until they tried to sell it. In DeSole, a Southern District of New York court concluded that the discovery rule applied to a toll and plaintiff's claims for fraud against an auction house in connection with the plaintiff's purchase of wine. Similar to the defendant in Soule, 1. Sotheby's is an old and deeply respected auctioneer. 2. The Halper catalog specifically stated that the auctions and the items therein would establish new standards in the areas of authenticity. And 3. The Halper catalog provided written assurances concerning the authenticity of the memorabilia prior to the purchase, in that it explicitly stated that Gray Flannel has authenticated all uniforms and apparel, excluding most baseball hats. In light of these assurances of authenticity, DeSole concluded that the fact that forensic testing was available to the plaintiffs at the time of purchase does not trigger the running of the 2-year discovery period, because the DeSoles had no reason to suspect the authenticity of their painting at the time of purchase. Here, too, plaintiffs had no reason to suspect the authenticity of the memorabilia at the time of purchase. Thus, the court finds that plaintiff's fraud claim would be told under New York discovery rule until June 2013, when plaintiff discovered for the first time that the items he purchased were inauthentic. Sotheby's argues in its motion to dismiss that the Halper catalog specifically did not state that the Gray Flannel authenticated the Mays travel bag. While it is possible that the language in the catalog was not intended to include the Mays travel bag, it would be inappropriate at this juncture to so conclude. Turning to Pennsylvania law, the Pennsylvania discovery rule tolls the statute of limitations in any case where a party neither knows nor reasonably should have known of its injury, in this case at the time his right to institute suit arises, and that's from Cole versus Ferrenti in 2013. And then you give a quote here. Under that rule, the limitations period begins to run out when the complaining party knows or reasonably should know that he has been injured and that his injuries has been caused by another party's conduct. It is reasonable to infer that the motion to dismiss stage, given plaintiff's statutes given plaintiff's status as an amateur collector who has relied on an apparent guarantee of authenticity from a well-respected seller, that he could not have known or reasonably should have known that he had been injured, while theoretically plaintiff here could have arranged for an independent authentication at the time of purchase. He had no reason to suspect the authenticity of his purchase that time. In reaching this conclusion, the court is also persuaded by Krauss vs. Cyclops Industries, in which the Pennsylvania Supreme Court cautioned that in determining the application of discovery rule, the point at which the complaining party should reasonably be aware that he has suffered an injury is a factual issue best determined by the collective judgment, wisdom, and experience of jurors. Accordingly, the court finds that, as in New York, the Pennsylvania discovery rule applies to toll plaintiff's claims until June 2013, when plaintiff was informed that the Mays travel bag and Mays jersey were inauthentic. Plaintiff's amended complaint was filed on April 1st, 2015, well within the period he has to make his claim under either New York or Pennsylvania law. Because there is no conflict between New York and Pennsylvania law, plaintiff's fraud and negligent misrepresentation claims are not barred by Pennsylvania borrowing statute. Sotheby's argues to the contrary, and unavailing. At oral argument, counsel for Sotheby's advanced two arguments that plaintiff was made aware of the alleged fraud prior to his interaction with Mears. First, counsel argued that the plaintiff was put on inquiry notice that there was potential issues with inauthenticity from the moment he read the auction catalog, because the warranty itself somehow should have alerted plaintiff to the fact that authenticity was an issue. Second, counsel argued that certain news articles that were published in cities outside Pennsylvania either should have brought the issue of potential inauthenticity to plaintiff's attention or demonstrated that inauthenticity was a commonly known problem. The court is unpersuaded by either argument. Sotheby's has fundamentally misunderstood the plaintiff's allegations. Plaintiff has not brought a claim for breach of warranty, he has brought claims for fraud. If plaintiff had merely brought a breach of warranty claim, Sotheby's argument that the 5-year guarantee should have triggered plaintiff to take independent action to authenticate the Mays memorabilia might be persuasive, but that is not plaintiff's claim. Plaintiff has not alleged that Sotheby's arranged the sale of the Halper collection, believing it had obtained Gray Flannel's authentication services, but due to inherent risks in the authenticity of sports memorabilia, it offered a limited 5-year warranty to protect customers while also limiting its own risk. Rather, plaintiff alleges that as early as the time Sotheby's contracted with Gray Flannel to catalog the Halper collection, Sotheby's knew it had not in fact hired Gray Flannel to authenticate the items in the collection, and fraudulently misrepresented that such authentication had taken place in order to induce customers to bid on the collection. Nothing about the 5-year warranty could have alerted plaintiff to that fact. For the same reasons, Sotheby's arguments concerning the news articles are irrelevant. Even assuming plaintiff knew or should have known that those articles were published, the articles stated only that there was some concern regarding the authenticity of the Halper collection. Nothing in the articles would have put plaintiff on notice that Sotheby's fraudulently stated that Gray Flannel had authenticated Halper collection when it knew Gray Flannel had not done such work. Economic loss doctrine. Sotheby's further moves to dismiss plaintiff's claims on the basis of economic loss doctrine. New York's economic loss doctrine denies the purchaser of a defective product or tort action against sellers for purely economic losses sustained as a result of the defective product, and that's in Hydro Investors Inc. versus Trafalgar Power Inc. from 2000. Under New York law, the economic loss doctrine applies to claims for negligent misrepresentation, barring plaintiffs' New York negligent misrepresentation claims here. Under New York's economic loss rule, a plaintiff asserting a claim of negligent misrepresentation who has not suffered any personal or property damage is limited to an action in contract. Accordingly, plaintiff's negligent misrepresentation claim must be dismissed. Sotheby asserts that New York substantive law applies to plaintiff's claim because of the choice of law provision in the conditions of sale governing plaintiff's purchase of the Mays travel bag and jersey. At oral argument, counsel for plaintiff stated that he agrees New York substantive law would apply unless the terms and conditions provision of the contract is not relevant to the claim that he made here. Plaintiff similarly asserts that his response brief that Plaintiff similarly asserts in his response brief that it has not yet been established that the terms and conditions in the catalog are binding as to plaintiff's tort-based claims. However, plaintiff advances no argument as to why the conditions of the sale provision would not apply and does not offer any additional choice of law analysis. Moreover, plaintiff's briefing includes citations only to New York law with respect to its common law tort claims and on New York, given the parties' reliance on New York law and absent any authority to the contrary, the court will apply New York's substantive law to evaluate plaintiff's common law claims. However, New York courts have routinely permitted intentional fraud claims to proceed, notwithstanding the economic loss doctrine. As for plaintiff's UTP-CPL claim, it is barred by the economic loss doctrine under Pennsylvania law. In Werninsky v. Ford Motor Company, the Third Circuit predicted that the Pennsylvania Supreme Court would find UTP-CPL claims barred by the economic loss doctrine, which they are intertwined with contract claims, and resulting loss has been economic. Here, because the plaintiff's allegedly fraudulent statements relate to the quality or character of the goods sold, the conduct plaintiff alleges defendant engaged in its clearly interwoven with a breach of contract claim and thus does not fall within the exception. Moreover, plaintiff alleges solely economic damages. Thus, plaintiff's UTP-CPL claims shall be dismissed. Recently, in Knight v. Springfield Hyundai from 2013, the Pennsylvania Superior Court held that the economic loss doctrine does not apply to UTP-CPL claims. Given this decision, several district courts have concluded that Werninsky is no longer applied. I have no idea what that is. I think it's Latin for something, but again, my Latin's really bad. It also says see Cantor vs. Heiko Energy 2015. I'm not gonna do that right now. I may at some other point if I really need to get some sleep. Anyway, the court, however, concludes that Werninsky remains binding law until either the Third Circuit, I'm not sure what that is, if that's another court case or what, that they're trying to attach here. It's just very strange. Anyway, this court, however, concludes that Werninsky remains binding law until either the Third Circuit or the Pennsylvania Supreme Court holds otherwise. D. Fraud. Alright, so they're getting to the fraud part here. Sotheby argues that the plaintiff's fraud claims fails because he has not alleged facts sufficient to support an inference of two elements for a fraud claim. 1. Knowledge of a false statement, and 2. Citing elements of fraud under New York law, a review of the amended complaint through the lens of a motion to dismiss standard shows otherwise. Plaintiff's fraud count does not contain sufficient factual matter accepted as true to state a claim to relief and is plausible on its face. Sotheby also argues that plaintiff's claims are barred by the conditions and guarantee that govern plaintiff's transaction with Sotheby's. Sotheby cites various paragraphs that provide a 5-year warranty of authenticity for the Halper collection and limit customers' remedy to rescission of the contract, while parties are free to enter into contractual clauses limiting liability to reflect the parties' allocation of risk. New York does not enforce agreements that purport to exonerate or limit a party's liability for willful or grossly negligent acts. And they state Kalish Jericho Inc. vs. City of New York, 1983, in which it states an exculpatory agreement, no matter how flat and unqualified its terms, will not exonerate a party from liability under all circumstances. Under announced public policy, it will not apply to exemption of willful or grossly negligent acts. Among other things, willful conduct in this context includes fraud. Accordingly, the conditions and guarantee cannot bar plaintiff's fraud claim here. In his complaint, plaintiff alleges that Sotheby's included language in the Halper catalog that it knew to be false with the intent to induce plaintiff to bid on items in the Halper collection. Specifically, plaintiff alleges that Sotheby's included language stating that Gray Flannel had authenticated the jerseys in the Halper collection when it knew it had not contracted Gray Flannel. In support of his allegation, plaintiff attached to his complaint the terms of agreement between Sotheby's and Gray Flannel, which indicated that Gray Flannel Collectibles would be paid $50,000 for cataloging and condition reports on 1,000 or fewer uniforms from the Halper collection. Notably, the contract between Gray Flannel and Sotheby's did not include the word authenticate. Nevertheless, the Halper catalog, portions of which were also attached to the complaint, include multiple alleged statements indicating that Gray Flannel had in fact authenticated certain items in the collection. For example, page 37 of the catalog states that, quote, Gray Flannel has authenticated all uniforms and apparel, excluding most baseball hats, unquote. In addition, the acknowledgments section of the catalog, which was published by Sotheby's, states that, quote, Gray Flannel Collectibles, Inc. is honored to have had the opportunity to evaluate and authenticate this wonderful collection of uniforms and jerseys belonging to Barry Halper, unquote. Based on these allegations, the court finds that plaintiff has sufficiently pleaded the elements of knowledge and intent. Conclusion. For the reasons stated herein, the Gray Flannel defendant's motion to dismiss is granted, and the Sotheby's and Halper defendants' motions to dismiss are granted in part and denied in part. With the exception of his fraud claim, all plaintiff's claims are dismissed. An order shall follow consistent with this opinion, and this is the order. And now, this 22nd day of July 2015, upon consideration of defendants Sharon Halper and Barry Halper, Inc., jointly the Halper defendants, motion to dismiss plaintiff's amended complaint, defendants Sotheby's Inc., Sotheby's Park Bennett Inc., Sotheby's Holdings, and Sotheby's, jointly Sotheby's defendants, motion to dismiss plaintiff's amended complaint. The motion of defendants Gray Flannel Collectibles Inc. and Gray Flannel Auctions Inc., jointly the Gray Flannel defendants, motion to dismiss plaintiff's amended complaint, the plaintiff's responses thereto, and the parties' supplemental letter briefs. 1. The Gray Flannel defendants' motion is granted. All claims against the Gray Flannel defendants are dismissed with prejudice. The Sotheby's defendants and the Halper defendants' motions are granted in part and denied in part. The motion to dismiss plaintiff's fraud and misrepresentation claim are denied. Plaintiff's claim for negligent misrepresentation is dismissed with prejudice. Plaintiff's claim for violations of New York General Business Code Section 349 are dismissed with prejudice. Plaintiff's claim for violations of Pennsylvania's unfair trade practices and consumer protection law is dismissed with prejudice. Plaintiff's claim for unjust enrichment is dismissed with prejudice. So as it turns out, that Mark Kokonin was going by a lot of the uniforms and jerseys in the Halper collection, and he's the one who may have overseen some of this stuff as well. Um, again, he's no longer alive, so we don't know what he may or may not have said about this stuff. But it doesn't bode well for his authentication either, just because we know that there's a lot of the jerseys are not real. It kind of brings everything else into question as well. And then the ones that have really got the huge hit here, the auction house here is the one who's taken a huge hit as well, because their reputation has been kind of soured on the Barry Halper collection. And I'm not entirely sure how often that Sotheby's actually does sports memorabilia auctions. I've known them to do like paintings and stuff, and that's brutal. Even the best authenticators can be fooled greatly by inauthentic or forged pieces of art. And it was kind of funny too, reading about this. Several years ago, there was an art case, an art forgery case in New York through an auction house that was selling forged material. And this auction house was around for over 100 years, a very old auction house. And they actually went under because they ended up getting sued. And I think that's what was interpreted in that lawsuit there, though I didn't read or I didn't see the name of the case, so that's kind of on me. But you guys can check that out too. And then again, in the art world, there are paintings that can't be sold, and it's a really interesting thing. It's again, it's aside from sports, but not really. They're getting a little more connected, closely connected, if you will, in the fact that in the art world, someone is going to steal a painting, it's usually because they can use it as a leverage to, get out of jail or use it in some other uh, crime, right? Or something, some kind of leverage. But because these sports cards and sports memorabilia is becoming more and more valuable, that probably could happen again. On the other hand, too, pieces of art are very difficult to sell on the black market because of the rarity involved. Say Vermeer. So Vermeer has probably 33 known paintings to exist. If you're going to steal one, you're not going to be able to sell it. And if you're in jail for something, say like Miles Connor, the art thief from Massachusetts, you're gonna you're gonna use that to get out of jail. I'm not entirely sure if you can do that with sports memorabilia or sports cards. They might just say, "Hey, yeah, go rot in prison for a while," right? But some of these cards are like one of ones, and they're like over $1 million or hundreds of thousands of dollars. So maybe at some point we might see this as well. I hope not. I really hope not. I do see like a rash of card theft, and some of it brazen, in fact. So uh, again, we're kind of entering a different territory here, a new era, if you will. And so I tried to clean up as much of that as I could for you guys. Reading the law is it's not easy anymore. It used to be. If you ever read any cases from the 19th century or even say the 1920s, court cases could be easier read than today. I really kind of consider this to be more of a game, a chess match, if you will, but a very boring chess match. Well, okay, so chess can be very boring too, but I think you guys know what I'm talking about here. A lot of these cases depend on case law, and sometimes there really is no case law. And you guys could probably really make probably a very good argument that the judge didn't really know what she was talking about here. And I may agree actually with that, and only because that she didn't introduce or nobody introduced the fact that there were several indications that Barry Halper may have committed fraud in other ways, specifically with the jerseys. So one jersey in particular that we know is fraudulent is the 1919 White Sox jersey, once belonging to shoeless Joe Jackson, or at least 1919 to 1921. Um, a lot of people have said that the acrylic used, and specifically the S of the jersey for the Sox logo itself, the acrylics weren't around in 1919, and they were invented in 1940. However, that is true up to a point. So acrylic was invented in about 1846 or so for paint, and it didn't make its self useful, if you will, in other areas such as clothing until about maybe 1940 or so. So it's a gray area there. Technically, that is true that the acrylic was not around in 1919 for clothing. So that is actually considered to be a fraudulent jersey. How many of these other jerseys and memorabilia from the Sotheby's auction catalog are fraudulent? And that's a good question because there's another example with Ty Cobb's diary, which has been proven to be fraud. And that was actually done by Al Stump, who was uh, supposedly he was the biographer of Ty Cobb, and Ty Cobb had fired him. Al Stump has actually done a number on other ball players as well, and it could be one of the reasons why Ty Cobb did terminate him from employment. And so Chick Stahl, the story of Chick Stahl from 1907, where Chick Stahl had supposedly drank a lethal dose of poison, and that did occur, but the reasoning for it is really not known, and it's been theorized, particularly because of an article that Alice Stump had wrote, I believe in the 1950s, where Chick Stahl had, I guess, impregnated a what they call a baseball Annie, or a groupie, if you will, in like 1906 or 1907, which caused his death. That comes from Alice Stump, and we're not entirely sure if that actually was the case. Nobody knows, in fact, but Alice Stump is the reason why people believe that that may have occurred. Again, we don't know. So the fact is, what I'm trying to get at here is that in the diary, it states that Ty Cobb, his mother had used a shotgun to kill Ty Cobb's father, when in fact the shotgun was a pistol. And there's an article from 1905 that specifically states this. And in the Halper collection was a quote unquote shotgun that was used to kill um, Ty Cobb's father. So we know that those two items are fake. They're forgeries, or they're just stories. And when it comes to stories on Halper, there's a lot of them, and a lot of them don't kind of coincide with actual events. And in one case, Halper had said that when he was playing baseball at the University of Miami, Jimmy Fox was his coach. However, the timeline does not add up at all. He could have had a autograph by Jimmy Fox, but it most likely did not come from his time at the University of Miami, where he was supposed to have played baseball under Jimmy Fox. Again, the timeline does not add up because Jimmy Fox was not at the school when Barry Halper was said to have played baseball. And then you have a few other cases as well, and an article from the New York Post, which was subsequently taken down, and that is from Pete Nice, if you will, a rapper who's also into sports memorabilia, and or Peter Nash, if you will, which is his real name. He operated the Halls of Shame, which I haven't read anything about that in a while. A lot of people state that he was a real authority on this stuff. There may be kernels of truth here. I'm not entirely sure because, again, he was taken to court over fraud in REA and Rob Lifson, and he actually lost his case. You know, Pete Nash did, and you guys can read up all about that. But there was a time when people believed Pete Nash to be a legitimate source, and he actually, I believe, may have lied under oath on a couple of occasions during a court case. So I usually don't like to talk about him. In fact, in regards to this stuff, but they did use a lot of his information for this, and I don't think it's any good, to tell you the truth. I'd like to know what you guys think about this. Again, there's a lot of really interesting things in this court case. Why the defendant actually lost his case, I think is kind of interesting to me, when it is known that these things were not actually, they weren't legitimate. And the fact that Sotheby's knew that they were not legitimate, or they didn't go after them in the way that they should have. They didn't do their due diligence, their homework, to find out if what they were purchasing was real. And then again, the only reason why you could probably make an argument that Barry Halper himself may not have known that the stuff that he was buying was not legitimate either. That's a good argument to make, in fact. Barry Halper does have legitimate stuff in his catalog, but again, you don't know what it is. And in one case, there's kind of a gray area, if you will, specifically around Billy Crystal's 1961 Mickey Mantle glove, because gloves are really specific. There are collectors who really, really know their stuff, right down to the stitching. And they are probably some of the best researchers that you're going to find, those who are specific to gloves and bats, in fact. I know that bats, for the most part, uh, especially when it comes to, I think, Hillerick and Bradsby, or not Bradbury, one of my yeah, don't forget I just said that, okay? Anyway, maybe Louisville Slugger or Hillerick and Bradbury, I can't I can't pronounce this stuff, guys. Anyway, those two companies, they have a lot of detailed documentation on the majority of bats going back to probably like the 1900, early 1900s, or at least 1910, 1920, and then definitely from the 1930s, 40s, 50s, and 60s, and maybe even 70s. So they're really pretty well established items. And Billy Crystal had bought the uh, the the 1961 glove of Mickey Mantle, thinking that he used it in 1961, and instead it was circa 1961. So the glove may have been around in 1961 or after 61. They're not entirely sure what the exact date is for that particular glove, or I think even if uh, Mickey Mantle used it at a later time, which he probably did, or an earlier time. So it's the authentication for a specific item during a specific time is vague at best. And I think he spent something like $200,000 on it. It was a huge amount of money. In fact, he said, "Don't tell my mother I spent this money or I bought this item." And he was able to return the item and get his money back. But that's not what happened here because of the time lapse. And it's actually a really good reminder of statutes of limitations, and they do apply. So only in specific instances, statutes of limitations do not apply after their course has ended. So you might want to keep that one in mind next time. And then the other thing too that I'm kind of reminded of is that gentleman who bought these two items, he said or he thought that these items were good, and that years later it had passed, and he went to resell these items that they all of a sudden said that yeah, they're fake, and that's why he went to uh, get his money back, and he couldn't because of the statutes of limitations. But it's still the fraud part uh, that was conducted by either Sotheby's or Barry Halper. And again, I'm not sure that you can definitely pinpoint fraud directly on Barry Halper. That's kind of difficult. I've heard a lot of stories about Barry Halper over the years from former ball players and other people associated with Barry Halper to suggest that he was a fraud. But I really don't have anything to specifically connect him to that to say you are definitely a fraud and here is why. It's all circumstantial, and a lot of people don't like to hear that. This case is, I think, one of the few cases that I can actually refer to in this regard that there is a problem with Barry Halper's collection. His baseball card collection, that's a different story. I don't think there's any fraud there, or at least I haven't heard of anything. It's just the memorabilia portion of the Barry Halper collection is suspect at best, and I think even the Hall of Fame does not rely on any of the materials that was given to them by baseball. So baseball actually purchased a lot of the items from the Halper collection to give to Cooperstown. Now, um, there there was another thing too that kind of piqued my interest, and that was Mark Conan. And Mark Conan, he did a really interesting book. I think maybe in the mid or early '90s. And I think I have it actually, and I've used it. And it's the baseball uniforms of the 20th century, and it goes through each team, their uniform changes. Now, I've used this book in for most of my artwork for major leaguers, and come to find out, he's supposed to be. He's unfortunately he's passed away now, but he is supposed to be the authority on Major League Baseball uniforms and really kind of everything you'd want to know about a Major League uniform for every team. And a lot of uniforms are very rare, especially the Negro League uniforms. I saw a few, and authentication of these uniforms is well, it's not easy for starters, especially trying to attribute the uniform to the specific player because apparently these uniforms would be passed down from player to player to player, and so you could uh, be given a uniform, or Mickey Mantle could be given a uniform, and then and one thing leads to another, and Joe Pepitone is wearing that Mantle uniform, and everything about it has been changed. So trying to figure this stuff out is really not easy. And so, anyway, guys, let me know what you think about this. I think it's a really interesting case, and I might bring this up in a future video, in fact. But uh, again, guys, thanks so much. I appreciate this. Uh, lawyer speak is not easy. I don't really like to do it. I do read a lot of this stuff. It's not good on a first date. Let me tell you, the ladies do not like this kind of stuff, but I hope you do. So I will talk to you later. All right, bye.